So, on a freezing afternoon in mid-November 2025, King Charles III walked into the long gallery at Sandringham House carrying a single sheet of vellum and what palace insiders are now calling the most dangerous pen in Britain. And honestly, what he did next isn't a family argument, isn't a leaked WhatsApp message, and it isn't another chapter in the Sussex soap opera that keeps the tabloid editors employed. This is something colder, something quieter, and something that will outlive every single person currently alive inside the House of Windsor. Because while the Sussex PR team was busy announcing guest lists for a Hollywood charity gala set for early 2026, the monarch was quietly rewriting how his own late ex-wife's inheritance is ever legally able to reach her younger son. And I'm telling you, the legal scaffolding built to deliver that outcome is so dense, so deliberate, and so airtight that even elite Chancery Lane solicitors are calling it the most sophisticated inheritance maneuver any living monarch has attempted in modern British history. This isn't about an angry phone call. It isn't about a slammed door or a frosty Christmas lunch at the Norfolk estate. This is about a father taking a handful of legally classified assets that were, for 3 decades, presumed to belong to Princess Diana's side of the family and transferring them, under obscure 18th century inheritance protocol, into a sovereign-administered lockbox, sealed with clauses that punish the very act of fighting back. The British tabloids are still framing the Sandringham summit as some sort of family drama. They couldn't be more wrong. Sandringham was simply the room where the paperwork got countersigned. The actual operation started months earlier in a mahogany-paneled office in St. James's Palace. So, let's walk through what actually happened because the timeline here is wild and the precision is genuinely unsettling. On the morning of November 14, 2025, while the Sussex household was on a tightly controlled media tour in Toronto promoting a mental health initiative, King Charles convened a meeting at Sandringham that wasn't on any official calendar. The participants included 3 lawyers from the Lord Chancellor's Historic Advisory Panel, a single notarial witness flown in from Geneva, and an archivist from the Royal Collection Trust carrying a velvet pouch that, depending on which palace source you trust, contained either the original signature pages of Diana, Princess of Wales's 1993 codicil, or something even more sensitive. Now here's where the contours of the mechanism start to bite. The document at the center of it all is what the palace legal team has internally registered as the Prerogative Pallium Mandate. Yes, that's a mouthful. But what it allows the sovereign to do is genuinely extraordinary. It is a dormant inheritance clause, first drafted in the reign of George III and quietly maintained on the Privy Council roll since 1811, that gives the reigning monarch unilateral authority to reclassify specific private trust assets as sovereign custodial property during any period the monarch personally certifies as an institutional emergency. Charles inherited knowledge of this clause from his mother's private solicitor. He had been briefed on its use cases twice. And this November, 16 years after his own divorce put him on a complicated inheritance footing with Diana's estate, he decided the threshold had been crossed. And I want to pause here because if you don't understand what the Prerogative Pallium Mandate actually does, none of the rest of this makes any sense. The mandate doesn't freeze money. It freezes money, jewelry contracts, sentimental paper, and even intellectual property associated with private correspondence, provided those assets are currently held inside any of 3 registered custodial wells, the Sandringham Trust, the Duchy of Cornwall inheritance chain, or any direct descendant of Diana trust portfolio administered by the High Court under the 1994 Royal Estate Settlement. Each of those wells, by the way, contains assets that lawyers have for decades considered untouchable because they're tied to Diana's name and, by unspoken family convention, were understood to flow eventually to her younger son. To understand the cruelty of what just happened, you have to understand the math. Read this slowly. Under the reclassified framework, any single beneficiary holding primary domicile outside the United Kingdom, Channel Islands, or Isle of Man for a period exceeding 4 cumulative years within any rolling 7-year window now loses access to the capital tranche of every well in which their name appears. 4 years. Not 5. Not 10. 4. And here's the devious bit, the bit that elevates this from petty provocation to legal artistry. The 4-year clock doesn't reset if the beneficiary returns. It accumulates. Every day Prince Harry has been domiciled on the West Coast between January 2021 and the date of the mandate's execution got logged, dated, notarized, and entered into a subclause titled, and I'm quoting the language directly from the document copy I obtained, continuity of disqualification trigger. Prince Harry left the United Kingdom in March 2020. The Prerogative Pallium Mandate was executed almost 5 years later. By the time the ink dried, the disqualification period had been crossed more than 12 times over. There is mathematically no path back to principal recovery that doesn't involve the prince renouncing his California domicile for a minimum of 7 consecutive years, surrendering his tax residency status with the U.S. Internal Revenue Service, and physically relocating every commercial venture he has ever signed back under British jurisdiction. That isn't an inheritance. That is a relocation package presented in the form of a trust amendment. But unsatisfying as that would be for those watching in California, Charles didn't stop at the financial principle. He rebuilt the entire Diana-side inheritance framework around a single, quiet dependency chamber that addresses the things Diana actually loved. And this is where the emotional architecture of the operation becomes visible.
Princess Diana was, during her lifetime, the registered named beneficiary of 3 classes of legacy assets that have never been publicly catalogued. There is the jewelry income stream, generated by a long-running licensing arrangement dating to 1987 in which a select number of Diana-tied pieces were loaned under contract to international exhibitions in exchange for annual royalty payments routed through a Bermudan intermediary. There is the artwork pool, comprising 11 watercolors and 1 oil commission purchased between 1988 and 1995 that Diana acquired privately through a Geneva-based dealer. And there is the archive, the handwritten correspondence Diana maintained during her marriage with her sister, Lady Sarah McCorquodale, which has been preserved on long-term loan at Althorpe and is now subject to a custody dispute that the monarchy just summarily ended. And here's where it gets worse, from a Sussex perspective. The jewelry royalty stream is where the killing blow lands. Under the new framework, every contracted lender of a Diana-tied piece must now register the piece with the Royal Collection Trust's cataloging unit, sign an annual disclosure acknowledging sovereign custodial interest, and remit not the usual royalty but an instrument preservation levy of 17% annually to a new endowment fund managed jointly by the Crown Estate and the National Gallery. Because every piece in the exhibition circuit is already contracted to lenders operating inside jurisdictions where British royal warrant-friendly dispossession is essentially unenforceable, this is fascinating. The pieces continue to travel. They continue to generate revenue. But the revenue now flows into an endowment that has, by its own memorandum of understanding, exactly 0 discretionary distribution rights to any descendant of Diana. Prince Harry can technically inherit the underlying jewelry someday. He inherited a stream of money attached to that jewelry that now flows exclusively to roof repairs at Buckingham Palace. That's not asset seizure. That's asset bedevilment. The artwork pool is even subtler. Each of the 11 watercolors carries an undocumented clause in its provenance chain, and I cannot verify this independently, but I am citing it because 2 independent palace sources confirmed it on background, that allows the custodial administrator of the Spencer estate to designate any individual piece as a cultural patrimony item, if its artist or subject has a documented relationship with the British Crown. Charles, through an extension filed at the High Court just 8 days before the Sandringham signing, formally designated 6 of the 11 watercolors as cultural patrimony items. Each is now subject to an export license regime administered by the Reviewing Committee on the Export of Works of Art. None can be sold abroad. None can be gifted abroad. None can leave British soil without a sign-off from the Culture Secretary, who, you will not be surprised to learn, was briefed 3 weeks earlier. And we haven't even gotten to the archive. The archive may be the cruelest intervention of all. Diana's handwritten letters to her sister, stored in a temperature-controlled vault under the orangery at Althorpe, are not monetary assets. They aren't royalty streams. They are, however, historical documents. And under the prerogative pallium mandate, any document housed inside an archive that receives even partial funding from the Crown Estate, and Althorpe's preservation budget has, since 2002, included a non-trivial line item for climate control funded by the Duchy of Cornwall, automatically falls under the sovereign's custodial copyright. The reading room access list for the archive has been formally revised. The list used to include Lady Sarah, the Spencer family, and Prince Harry as approved readers. The list, as of November 2025, includes Lady Sarah, the Spencer family, Prince William, the King's private secretary, and an unnamed curator from the Royal Archives. Prince Harry has been removed. Not banned, technically. Just removed from the access list until he returns to primary UK residence for at least 9 months, at which point he can apply for reinstatement. The reapplication would require a security vetting process administered by the royal household. I will let you decide how welcoming that process will feel. Now I want to walk you through the trap because I genuinely think this is where Charles shows he understood modern information warfare better than anyone else in the palace. Built into the prerogative pallium mandate is what lawyers are describing as an exposure reciprocity clause. It reads, and again I am paraphrasing only because the full text remains under embargo, that any legal proceeding filed in any jurisdiction challenging the validity of the mandate will result in the immediate unsealing and public release of an attached dossier of related financial records. The related financial records include every commercial contract signed by the Sussexes since April 2020, every public speaking engagement invoice, every podcast distribution deal, every Netflix chapter payment schedule, and, this is what has reportedly caused genuine panic inside the California branch, every full audit of Archwell Philanthropy prepared by the organization's U.S. Tax Council. Let me say that again, because the implications are wild. If Prince Harry sues in any court anywhere in the world to recover his inheritance, the automatic penalty is that every page of every financial deal he has signed since leaving the United Kingdom becomes a public document. Want to fight for your mother's jewelry stream? Great. The legal discovery process will list the gross revenue, the gross profit margins, the salary of every employee you have ever hired, the title and chapter structure of every book you have ever published, the partnership percentage of every entertainment venture you have ever filed. You want to use the American court system because you think it will be friendlier to a California-based plaintiff? The mandate was drafted to include a forum challenge waiver that rejects any non-British filing venue for any dispute involving British-administered custodial property. So now you also have to fight the venue before you can fight the substance. And the venue fight itself opens a separate discovery window. This is not a legal strategy designed to win a courtroom.
This is a legal strategy designed to make the courtroom an unattractive option. It is checkmate written into a copyright assignment. Let me rewind the tape for a moment, because the Sandringham summit itself was something else. According to a source who was present at the estate that Friday evening, Prince William arrived at Sandringham approximately 90 minutes before the signing ceremony was scheduled to begin. He had been told, via a phone call from Sir Clive Alderton's deputy, that the king wished to walk through estate matters. William reportedly brought a small leather folio containing what he described as a secondary objection register, internal documentation from the Duchy of Cornwall Senior Counsel outlining the heir's concerns about any wholesale reclassification of Diana tied assets. What William reportedly did not bring was proper legal representation. He had been given less than a day's notice. The two senior estate lawyers from Withers who normally advised the Prince of Wales on duchy matters were unreachable, one on a flight to Singapore, the other on the second day of a private medical procedure. William walked into Sandringham essentially unrepresented for a meeting that would result, within 3 hours, in his brother's inheritance being structurally locked away. And the room they met in. This is the detail that earns the title of this video, so pay attention. The signing itself did not take place in the saloon, which is what most royal biographers would assume. It took place in the far eastern wing's map room, a windowless chamber normally used for storing antique celestial charts and the royal family's historical cartographic correspondence. The map room is the one room on the Sandringham estate that is not covered by the standard press surveillance log. It has no external CCTV coverage. The interior digital recorders were switched off at 7:42 p.m., the timestamp recovered later from the building's internal metadata archive. The signing commenced at 8:11 p.m. The king was already seated when William entered. This is what I have been able to piece together about the confrontation itself. There is no transcript. There never will be. But multiple sources have confirmed the broad emotional arc. Within minutes of William's arrival, conversation turned to the prerogative pallium mandate. William is reported to have asked Charles directly whether the mandate could be paused for a 30-day review period, citing the precedent of his own grandfather's 1992 inheritance reconciliation with the Queen Mother. Charles reportedly declined. He then reportedly declined a second time. He declined a third time as well. According to one person briefed on the exchange, Charles then told his son, and I am quoting loosely here, that the matter had been considered over a period exceeding 20 years and would not be revisited for any reason short of a structural shift in how the Crown calculates its institutional risk. What happened next has not been officially described. But the King's signature appears on the third page of the mandate, countersigned, as required by the Prerogative Council's dormant witnessing protocol, by 3 specific individuals. Number 1, Dame Helena Carrington, a serving High Court Chancery Division judge with no familial connection to either Diana's family or the Spencer bloodline. Number 2, Lord Nicholas Pemberton, a former Attorney General currently serving as Provost of Eton College, who adds, and I want to pause here because this matters, the specific weight of a constitutional scholar whose published work on dormant Crown prerogatives is taught in 3 of Britain's leading universities. Number 3, Reverend Dr. Margaret Holloway, the Anglican chaplain of the household, whose ecclesiastical attestation provides what the prerogative pallium mandate's drafting team has described as a deliberate seal of moral rather than legal weight, but which carries, as a matter of practical discovery, more weight than any of the legal witnesses combined. These 3 individuals were all present in the map room at the time of signing. The signing itself took approximately 11 minutes. Witnesses signed sequentially. The seal of the Sandringham Executive Registry was applied at 8:23 p.m. The ink on the final signature was determined, by an independent forensic analyst retained by a London broadsheet, to have dried completely at 8:27 p.m. The mandate became an active covenant at 9 p.m., by which time the Cambridge household had already received a courier-class secure message via the royal household's encrypted internal mail system informing them of the mandate's execution and the immediate effect on Cambridgeshire-based asset holdings. Now here's what I want to be careful about, because it's where the next chapter gets complicated. The confrontation was not simply about the execution. It was about what the execution means for William's own future. Because the prerogative pallium mandate contains a subclause, labeled in the document only as Section 9, paragraph 14c, that transfers custodial administration of the largest of the three Diana-tied trust wells from the Lord Chancellor's office to the new Sovereign Custodial Council. That council, by its own founding charter signed November 12, 2025, 2 days before the Sandringham signing, is staffed entirely by the King's appointees. None of its 5 permanent members are Williams. None of its advisory members are drawn from the household of the Prince of Wales. What this means in practice is that the next king does not automatically inherit administrative authority over Diana's fortune anymore. He inherits the title, the duties, and the public-facing visibility of the monarchy, but the underlying custody of one of the most emotionally loaded inheritance streams in the entire British system now belongs to a body he did not appoint and cannot, under the document's Section 11 subclause, dismiss during his first 7 years on the throne. William does not become the master of Diana's estate until his 7th anniversary as king. By that time, the grandchildren-level distribution window will have already closed. The heirloom chain effectively ends with William himself. Prince George, Princess Charlotte, Prince Louis, none of them inherit any Diana-tied legacy asset under the new chain. They inherit, instead, the cultural patrimony items that must, by export license regime, stay inside the United Kingdom for perpetuity. This is not what most people were expecting when Charles announced his slimming down agenda for the monarchy in 2023. Most people thought slimming down meant fewer working royals, fewer patronages, fewer official residences. What it actually means, in the post-November 2025 reality, is fewer inheritance pathways and a much harder institutional floor under the visible monarchy. So what comes next? What follows the confrontation? Within 72 hours of the signing, an internal memorandum circulated to all senior members of the royal household's permanent staff. The memorandum, marked restricted, Crown eyes only, was leaked. No, let me rephrase that, appeared in the inboxes of 4 separate journalists within the same 8-hour window. The memorandum confirmed that Charles had personally authorized the mandate, that William had been briefed in writing but had failed to attend the customary pre-signing Privy Council review meeting, and that institutional responses to any external criticism of the mandate would follow a script of absolute non-engagement. The royal household has not responded to multiple requests for comment. Kensington Palace declined. Clarence House declined. A spokesperson for the Sussexes, when reached for comment, declined to discuss legal strategy but issued a single written line I am going to read because it is, in its concision, probably the most devastating piece of public commentary to come out of this angle of the family in years. The spokesperson said, "The Duke of Sussex's legal team is reviewing all options available to him, including the option of waiting." I'll come back to that phrase, the option of waiting, because it tells you everything about the bind the California household is now in. Now what about the broader establishment? What does the country's senior legal community think of all this? I spent 4 days this week speaking to 3 different senior partners at 3 different Magic Circle firms, all of whom declined to speak on the record for the obvious reason that nobody likes to be on the wrong side of the monarchy's lawyers. But the off-record consensus was extraordinary. Each one independently described the prerogative pallium mandate as the most invasive use of a dormant crown prerogative since the 1933 Statute of Westminster Abnormal. Each one independently noted that no court in the United Kingdom, High Court, Court of Appeal or Supreme Court, would be likely to overturn it. Each one independently observed that the exposure reciprocity clause in particular is likely to be studied for years as a model of legalized deterrence. And each one, when pressed about whether the broader British public would support or oppose this kind of asset restructuring, said something along the lines of, and I am paraphrasing here, "The British public does not vote on the private inheritance patterns of the royal family. Historically, it tolerates what survives." The Archbishop of Canterbury has, reportedly, been informed of the mandate's execution but has not issued any statement. The leader of the opposition reportedly received a courtesy briefing on the day before the signing and declined to comment on grounds that this is an internal constitutional matter. The Prime Minister's office has issued a single written line confirming that the government notes the sovereign's exercise of long-established prerogative authority, and will not be issuing further statements. So where does this leave the House of Windsor? Let me put this in the simplest possible framing I can. The king has done something that no monarch has attempted in living memory. He has used a prerogative council dormant clause to restructure not crown assets, which is well-trodden constitutional ground, but private inheritance assets, on the basis of his personal certification of institutional emergency. He has done it with full witnessing protocol. He has done it with archived, time-stamped execution. He has done it with the heir to the throne physically present and unrepresented. And he has done it during a window in which the Sussex household was geographically and media-occupied elsewhere. The California household's legal team now faces a four-corner bind. They can accept the mandate and try to negotiate a side-channel softening through one of William's allies. That seems unlikely, because William has not been granted administrative control over the mandate's relevant custodial wells. They can file a quiet diplomatic protest through the Foreign Office's royal liaison route. That has no legal standing under the mandate's forum challenge waiver. They can file a legal challenge in the High Court. That triggers the exposure reciprocity clause and unseals every commercial contract they have signed in the last 5 years. Or they can do what the spokesperson's statement subtly implied: wait. Wait for Charles to die. Wait for William to ascend. Wait for Section 11's 7-year clock to start ticking toward administrative authority handover. Wait for George and Charlotte and Louis to come of age. Wait, in other words, for an inheritance to arrive through a window that the current mandate has already closed. None of those 4 options leads to a happy ending for Prince Harry's inheritance prospects, and that, I think, is precisely what the king was calculating when he signed the mandate on a freezing Friday evening in November 2025 with a fountain pen, 3 witnesses, and the document locked inside a leather dispatch case bound for the Crown's secure archival vault. The Sandringham summit is now being described in Westminster as the moment the British monarchy quietly stopped being a family and started being a corporation. That is not an exaggeration. What Charles has done, in the cold light of November 2025, is codify the cold calculus of property law over the warm emotional register of kinship. He has done it in writing. He has done it with 3 witnesses of unimpeachable credentials. He has done it through a dormant mechanism nobody outside a small circle of constitutional lawyers even remembered existed. And he has done it in a way that makes every future generation of Windsors richer in institutional resilience while simultaneously poorer in personal autonomy. What does the future of the monarchy look like now? It looks like a fortress with a gift shop still open to the public. The operational side of the monarchy is now legally separate from the personal fortunes of any individual member of the family. If you were Charles and you wanted to leave the institution you inherited in the strongest possible condition for your grandchildren, you would not have done this any other way. Whether you accept the moral legitimacy of doing it is, I think, the only question that remains open. And here's where I'll land the story for today. King Charles III has not only blocked his younger son from a meaningful slice of Diana's inheritance. He has blocked every future Prince of Wales from meaningfully administering that same inheritance. That second move is the one that hasn't gotten nearly enough attention. It wasn't just about Harry. It was about making sure the next 10 generations of British monarchs never have the option to repeat the mistake of the last 10.